Today, we're joined by Ms. Raveena Kumari Sethia, a lawyer and educator whose work spans across legal practice, teaching, and community initiatives. Ms. Sethia is a principal associate at Shardul Amarchand Mangaldas in New Delhi, where she works with the competition law team. She also serves as a visiting faculty member at NUS and Jindal Global Law School. Beyond her professional practice, she's committed to pro bono teaching and mentoring. To this end, she's the co-founder of Abji Vijay Singh and Rani Aruna Kanwar Foundation, which works in the fields of sports, animal welfare, and the upliftment of women, children, and marginalized communities. An alumna of the Jindal Global Law School, she completed her master's at the University of Cambridge as a Justice Pratibha M. Singh and Cambridge Trust Scholar. She's also gained experience with other leading law firms in India and abroad, including a training contract offer from Herbert Smith Freehills, London, and a stint with Trilegal's competition team in Mumbai. We're so glad to have her with us today to talk about the effects-based analysis under Section 4 of the Competition Act and its growing importance in India.
Thank you. Thank you so much for having me and, for that introduction. You want to start
Right.
with?
So, yeah. So, just to start off, for the audience that is less familiar with the subject, what is the effects-based approach under Section 4 and how is it different from the forms-based analysis?
Right. So essentially, the idea in very simple terms is that in abuse of dominance cases, and I understand this is a podcast with a platform wider than simply students of competition law or people who would have studied this topic. So just to even take a step back from that aspect, the role of competition law in our country is to ensure that there is effective competition across sectors. So it's a sector agnostic law which seeks to see and stop anti-competitive practices and behavior and promote competition as well as for work towards the benefit of consumers. So towards that end, certain type of conduct is regulated and certain type of conduct is prohibited. So if there's a company which is dominant, for example, it's a really large company, it's a leading player in its market, its closest competitor is very far behind from it, it has very high market shares, their consumers are dependent on it, etc. It may be classified as a dominant company in a particular relevant market under the law. And once a company is designated as dominant, then there is a special responsibility of sorts cast on it to act and behave in a certain manner. So, for example, if there was conduct or if there were things that another regular player could do in the market and get away with, a dominant company may not necessarily be able to achieve the same, do the same, conduct the same practices with the aim to achieve the same outcome. So, if a dominant company under the law engages in certain type of conduct, which includes, for example, denying market access to a competitor, imposing unfair restrictive agreements, engaging in discriminatory behavior, etc., then certain types of conduct come under the scanner of the regulator and they may be penalized for such action. So far under competition law, the standard really legally has been that you must only establish what the relevant market is, which is what is the market in which this company is operating, where it's supplying its products, where it's supplying its services. Secondly, you must see whether that company is dominant or not based on its market strength, closest competitor, dependence on consumers, how much power do consumers have, etc. And once you've established that, you only had to see whether they've engaged in any conduct which is prohibited under the law. So, for example, if they had entered into a one-sided sort of agreement, or they had engaged in discriminatory behavior vis-a-vis sort of two customers at the same level, then that itself would have been enough to say they have abused their dominance, which is a violation of the law, which could have resulted therefore in penalties, which could have resulted in cease and desist orders, and in certain extreme cases, even remedies being imposed on them. So that was the standard in a sense legally. And even till recently, when the Competition Act was being amended and there were discussions among the Competition Law Review Committee, they took the conscious decision to say that the law itself is flexible enough right now for the regulator to be able to see conduct on a case-by-case basis. So they did not really change the legal standard applicable to a great extent. What the effects analysis requirement kind of does is that it now mandates a fourth limb in abuse of dominance cases, which means now not only will you see the relevant market, not only will you see dominance, not only will you see what the conduct is, but you will now also have to assess what has been the impact or likely impact of such conduct on the market. This is something that has been done by the CCI on an ad hoc basis, on a case-by-case basis, really. But it isn't something that so far was a required mandatory sort of standard to be fulfilled in all sorts of abuse of dominance cases. So that's something new that we see here, which is something brought about by, firstly, the NCLAT in the Google Android decision of 2023, followed up by the Google Play Store decision of 2025, and of course the Supreme Court's Schott Glass judgment also in 2025. So the trend has been towards now seeing the impact of what this sort of conduct is. And this is different from what we understand to be a form-based approach, which is essentially a tick mark approach where you see that this is the market, this is the dominance, this is the conduct, and that's it. You don't need to go a step further to see what the impact really has been. So that's the difference sort of between the two. The idea behind the form-based approach also, it's not an illogical standard, it's just a standard which has a higher burden. The reason for the higher burden is that if you are a dominant company and you're really big in the market, then the law expects you to behave in a certain way. And therefore, a lot of legislatures around the world don't want to give dominant companies that little window where, they think that they can even engage in such conduct and maybe get away with it. So the form-based approach sort of puts them at a higher threshold that don't even try doing this. However, the effects-based standard is a more rule of reason-based approach where you will now see what the conduct is. Has it really resulted in anything? Is it likely to really result in anything? If not, then that conduct also should be kosher, it should be okay despite the company being dominant. So in very simple terms, that's really the difference, and that's what the jurisprudence has evolved to be.
Right. You were speaking about how prior to some of these decisions, it used to be more on an ad hoc case-to-case basis. And the Schott Glass case seems to change that. And the CLRC report approved of this approach, given that such analysis may not always be necessary in every single case. For example, what, in your opinion, are some of the disadvantages of mandating this analysis for every single inquiry under Section 4?
I don't think there's a disadvantage per se. I think what will have to happen is that a regulator now will really need to see the types of conduct coming before it and then see the manner in which it can assess the effect or the impact. This actually is beneficial for the market in a way because it avoids over-regulation, which is the largest problem really when you look at competition cases, right? Like a lot of times you see there are cases that come in, we as practitioners experience this a lot, that there is conduct which is there undoubtedly. Nobody can say that the conduct in a broad sort of based manner doesn't exist. But at the same point of time, we end up seeing circumstances where that conduct occurred due to a very, very specific, objective, justifiable reason, and honestly did not result in any impact on the market whatsoever. So when you get those sort of cases, you feel like, they're going to be penalized for no reason. And we will be in litigation for years and decades to fight this out and argue our point. And eventually it'll all become infructuous because of the passage of time. So what the effects-based standard really does is it saves that regulatory energy and time to a great extent in terms of not reacting to potential conduct or conduct which could have this sort of hypothetical impact without there being any evidence of that sort. It also ensures that these companies and dominant players aren't being penalized for innovation, simply because they are large players, simply because they're doing something which is innovative or different or have a first mover advantage simply from their competitors. So it's really something which is going to help in terms of leading to appreciation of on-ground facts by the regulator. So to give you an example, in the ONGC case, there was a one-sided contract where ONGC would have these agreements with ship owners, and it would take the services of these ship owners for certain drilling activities. That had a one-sided termination clause where for termination of convenience, only ONGC had the power to terminate the contract. The counterparty did not have this power. And that clause was in the contract. It was one-sided. It was, on the face of it, it could have been abusive, depending on the way one saw the facts. However, the CCI, and this is before all this effects wordplay came into being in the last 2 years, the CCI itself realized that this clause has been there for 35 years and it was never exercised by ONGC. It was only exercised one time in 35 years just because of the way oil prices were fluctuating around the world and the economic devastating impact it had on drilling activities. So they had to terminate those agreements because they couldn't afford to do the drilling, right? Like, it was a logical, justifiable action, especially for a company which is, like a PSU in that sense, right? So they have to preserve government resources. They can't just act brashly because they need to continue with contracts despite suffering a loss. There was evidence of, a CAG report which actually directed them to sort of stop that engagement or contract because it was leading to losses for the exchequer. So there was a lot of justifiable evidence that one placed on record, and the CCI actually agreed in that case and said, yes, this is not abuse of dominance. This has been done for a specific reason. It's a one-time thing, and it in its way did that effects analysis really without it being on the books. So sometimes, even if a clause appears to be one-sided, or you want to you're tempted to take that form-based approach, looking at effects can really help in reducing such overregulation, and it can provide a better platform for application of competition law in the manner that it's intended to be. If something is done for a genuine objective reason and it's to exclude a competitor or cause an anti-competitive penalized necessarily because of rigidity in the law. So I think that's where this is going to really help, and there's no real disadvantage to it per se. Of course, the manner in which effects are assessed will depend on cases, which gives enough flexibility to the regulator in any case. But this is something that the CLRC noted the CCI was doing anyway on an ad hoc basis. They felt like it was not required perhaps in all cases, and that could have been their assessment based on the way jurisprudence had developed till that time. However, that doesn't mean that it cannot be done just because it wasn't. So in my view, I think you can conduct that same analysis even as far as purely exploitative abuses are concerned as well, or even conduct which on the face of it appears to be anti-competitive as well. You can apply the same standard and you can see how it plays out in those facts and then assess the scenario.
I just wanted to ask, this is from the point that you talked about flexibility and the sector agnostic thing. So while the court in the Schott Glass case, it mandated demonstrable evidence of harm to establish abuse of dominance, it did not necessarily lay down a framework for how this analysis has to be conducted in the first place. So do you think that the court missed the mark by not deploying a framework, or do you think that a detailed framework, if the court had established, it would, risk having an overly rigid standard for future inquiries on a case-to-case basis?
Yeah, I think the court moved away from setting a specific standard or a bright line test for a reason, and that's because you can't really, if you're applying the standard to all sorts of cases, you can't really have a bright line test. It'll have to depend on the nature and type of conduct. It will have to depend on the facts at hand, and even the sort of economic and social circumstance surrounding that conduct as well. Like a PSU may do something based on guidance or a mandate from a presidential directive or from another department of the government. So that social context also sometimes becomes important. And like in ONGC, the economic context becomes important. So unless you take all of them into account, it's very difficult to have a bright line test which would universally be applicable. So I think they deferred, or they sort of restrained themselves from applying a test for that particular reason. And they also probably must have felt that the regulator is best equipped to deal with things on a case by case basis, depending on the facts that come before it. However, that said, the principles in Schott Glass are very clear. Just for context, they found that this framework for conducting an effects-based analysis is already available in what they call the legislative signposts within the law itself. They found it not only in the preamble, they found it in the way Section 4 is worded, they found it in the way there is implication under Section 19 as well. And they also sort of found it in the way that they were generally able to see that this whole concept of there being this effect on the relevant market or a relative advantage in the way that the text is worded would itself ensure that this had to apply in a contextual sort of manner. So they found that this inherent power to conduct this analysis already exists. They found that you must do it as well in every case, because it is something which is built into your law, which gives enough power and flexibility to the regulator to be able to see what the facts at hand are and how they want to sort of encompass this. The way the jurisprudence has developed through Schott Glass, and not just Schott Glass, but even through the decisions of the NCLAT and the Google cases, has now helped us as practitioners and even dominant companies understand what is it that they're looking for, right? So just to summarize, what the principles we've understood from this is that there must, number one, have been conduct. You can't penalize a company when there is no conduct that has taken place, number one. Number two, such conduct should have actually resulted in actual or even likely anti-competitive effects. So that's the other thing that the NCLAT has helped us clarify, that effects need not have always manifested in the market, but that they could also be likely. As far as the conduct has occurred, that much flexibility exists with the CCI. So in this way, jurisprudentially, even though Schott Glass is silent a little bit on this aspect, the Google cases by the NCLAT and Justice Bhushan have helped to clarify that and take it one step further. So using this as the framework, now today the CCI can actually conduct its own sort of test where it sees, hey, has this conduct occurred or not, number one, what they're complaining about. Number two, if it's occurred, does it have any actual effect? If not, number three, does it have any likely effect? And if there isn't any actual effect or likely effect based on the evidence at hand, then they are well within their powers to dismiss such a complaint and find that there in fact has been no abusive conduct. So I think based on these sort of jurisprudential principles, when they're brought together, while you don't have a bright line test, you do have sufficient guidance and tools to be able to apply them on a case to case basis. The trick actually is in terms of what the evidence should be when you are conducting an effects based analysis. That's something that nobody has really commented on, like what do you need to really see? Because if in our investigations with the CCI, what we typically see is that the CCI conducts third party outreach. So they will have responses from certain competitors or customers or other analysts, etc. Secondly, they will have evidence of what your market shares are, or how conduct, like price would have fluctuated or market shares would have fluctuated. Third, they would have evidence based on market reports and market studies, based on how the market is really sort of coming into fore. So these are the things that they typically rely on. Now the question and the trick really becomes is, simply because they've done this outreach, is that enough for them to say that they've satisfied their burden? Or is the manner in which that outreach is done and the weightage given to the correct sort of responses from the correct responders also equally important? And I would think the latter plays the biggest role, right? You could reach out to 10 people, but if you don't ask them the right question, then you would never get the right answer that you need. That's number one. And number two, those 10 people may even respond to you with an agenda of vindictiveness in mind. So you need to be able to filter that out to actually be able to see which out of these is a genuine response that genuinely from with some sort of reliable evidence or some sort of reliable even theory of harm is able to establish that the conduct in question is problematic. So that really is where I think this becomes tricky rather than simply, putting a bright line test.
Ma'am, to what extent can non-price metrics be relied upon to demonstrate harm for abuse for dominance? For example, within the sports industry, especially in commercially structured leagues, such as the Indian Premier League, how should exclusive broadcasting rights and franchise-related restrictions be assessed under an effects-based approach? Can such arrangements, while commercially justified, nonetheless lead to long-term market foreclosure, heightened entry barriers, or a distortion in fan engagement, which these days is the focus of franchise-based brands and team competitiveness? Would these effects satisfy the demonstrable evidence requirement under Section 4 of the Competition Act, even when no immediate price harm to consumers can be demonstrated?
Well, that's interesting. So I think when you're looking at non-price factors, it's very important to assess them with a pinch of salt, because not all non-price factors are as relevant. That's number one. I think number two, and especially when you have digital markets, for instance, then you have to see that some of these products are being provided to users absolutely free of cost. So you have to weigh that benefit against whatever you think is the problematic conduct or these non-price factors, and then assess really what the impact is going to be on competitors or consumers. So for example, if you have a scenario where there is a zero price product in the market, which is able to be used by consumers for free and actually benefits them for whatever reason, then you have to assess in contrast to that, what are the non-price factors that you're looking at and how do they really impact competitors? Have they hindered entry for competitors? Have someone actually come and complain to you about certain conduct? Has it resulted in some sort of denial of access to any player in the market? Has it actually resulted in restriction of any kind on technology or on, any sort of proprietary information without which a competitor would not be able to function? And then weigh that against the benefit that consumers obtain from that product being free. Because tomorrow you don't want to over-regulate, and just say that you're offering something to somebody for free. However, we think that, because you're doing, because you're collecting, for example, basic contact information, or because you have access or you're present in multiple different markets, that itself is sufficient for you to be abusing your dominance and result eventually in not any new competitor or any landscape changing in the market, but that product no longer remaining free for competitors. Like, that's something that you don't want then, right? Like, eventually you have to weigh it in a systematic manner and see what the pros and the cons are. To take your example of broadcasting rights, for instance, in that scenario you have a situation where there will be one player that will have these exclusive rights. However, you need to see, is that a long-term contract? Is it really going to impact other players in the market? Are they not going to be able to secure the same contract on a level playing field, in the next cycle? Is there evidence of the same person getting those rights again and again? Is there evidence of there being no competition in the market for those rights? Is somebody actually complaining and saying that I'm not able to sustain in the market as a general broadcast player just because I don't have access to this transient agreement for this game, which is going to only be there for a limited period of time? And accordingly, you sit and you assess, because you want users to be able to also access that game through a platform which enough users are using. Otherwise, there's no benefit in that contract going to somebody like Lionsgate Play, for example, that hardly has a user base in India. So you end up making the product or that watching experience more expensive for users in certain cases. So I think you would have to assess this looking at all of the facts and really see what the actual or likely impact of that arrangement would be, right? And especially where you have an auction seasonally, it's not just like a long-term contract, but something only for a year, 6 months, 2 years, 3 years. Is it really something that you can say would hinder entry in the long run for all players? Is it something that's locking in viewers or even, the IPL, for example, with that player or not? So you'd have to see it holistically.
The next question that we have for you is about this a theory of harm and how important it is and how it plays into an effects-based analysis. How important is it for competition authorities to clearly articulate a theory like this? And what risks are we looking at if such a step is overlooked or it's insufficiently theorized or developed? And a connected question is about how this connects to the question of evidence that you were talking about, that so far the kind of evidence that we look for is fairly underdeveloped. Can this theory be of any assistance or guidance in that regard?
Yeah, I think it is important to have a clear theory of harm, because without that, it's frankly this endless goose chase, right? And without knowing what you're looking for, or without trying to identify the type of harm something has caused, if you simply conduct an investigative exercise without any signposts for yourself or without any contours for yourself, then you don't know what you're looking for. The sort of what to say, the conduct, the exercise is very misguided, and it ends up becoming a overall wasteful experience for the regulator as well. So it is important to start with some theory of harm. I think once you have that theory of harm, then there is an investigation, of course, that will be conducted by the directors general. Why conducting their investigation under the premise of that theory of harm? If they come across certain additional evidence, or if they come across certain additional facts that lead to the development of a new theory, that's always, of course, some flexibility that they have to go through. They have that path available always. However, if that's not the case, then at least they are coming to some conclusion, either yes or no, regarding that one theory of harm at least. So we've seen a lot of cases that come in where, for example, the prima facie order is, very broad based, and the investigations then therefore end up taking a very different turn from what's probably intended. The investigators aren't able to articulate the right questions or reach out to the right parties or conduct a thorough enough analysis, due to which then the CCI has very limited relevant material to rely on while coming to an actual answer, or to come to an actual decision on that theory, or to come across, even like, that's why the analysis a lot of times in those cases is quite random, because they don't know what to rely on beyond the point. Those are the decisions that often end up getting appealed so often, and you see the NCLAT and erstwhile compact sort of turning them down. Schott Glass itself is sort of one example where the CCI just relied on the wrong metric to be able to say that there is abuse of dominance, when there was ample to show that there was no such foreclosure in the market. The conduct was objectively justified. The discounts given were on a reasonable volume basis, and there was no issue, frankly. And that's why, in that case, even the compact rejected the CCI's opinion, because they said this is just not based on any analysis at all. So, you need to have some theory to start with, so that your investigation and then eventual material becomes relevant. And this theory can be broadly exploitative or exclusionary. That's like your broadest sets. And then within that, you have your subsets of the particular sort of harm that you're looking at within that conduct, right? Why is it exclusionary? What have they done? Is it through contracts? Is it through conduct in the market? And you build it on that basis on and forward. But if you don't have that theory to start with, or that signpost to start with, it's a random goose chase, which is just not, helpful at all. And in terms of, um, the the evidence requirement, I think the evidence ends up playing out significantly once you have that theory of harm in place. So, for example, if it's exclusionary conduct, which means that a new entrant is not being allowed to enter, or an existing competitor thinks it's not able to sustain, you would look at certain types of evidence. For example, you would see, are their market shares declining? Are the contracts that they have with other people in the market reducing? Is there evidence that they're being taken over by one and the other? Is there evidence that there has been no new entry or the market has been stagnant for decades? Is there evidence that only the leading dominant player is able to secure contracts and agreements? So your questions would be framed in a manner depending on the theory of harm. And therefore, your evidence that you collate will also correspond with that. However, if you don't do that exercise, then you might ask 25 questions and you might get 25 different data metrics, but all of them might not be helpful in any assessment.
Throughout our conversation, you've mentioned the challenges that the CCI's investigation may face, including the somewhat unclear evidentiary burden that they may have to prove. In this context, how can the CCI strengthen its institutional capacity, both in terms of technical expertise and procedural tools, to effectively carry out complex effect based analysis? Should there be a specific timeline involved to prevent delays in investigation?
Right. I think that's very important. And I think it's something that the CCI itself is cognizant of as well. So I think in terms of the tools that they have at their disposal, they already have the ability to reach out to special experts on a case-by-case basis. And I do think they must make the most use of that, to start with. So because there are a lot of cases that play on different markets. And a lot of times what happens is that because the CCI is a broad regulator and not a sectoral regulator, it may end up missing crucial, points which are specific to an industry, and therefore ignore on-ground evidence relevant for the case. That gap can really be fulfilled when you get somebody who's an expert in a sector and come and explain to you, this is really how this works. And so, to a great extent, you might be able to understand why parties engage in certain type of conduct. To give you an example, there might be an industry where there is a dominant player for sure, but rather than engaging in conduct that's actually detrimental, it might be engaging in conduct that actually helps, players in the industry. And because it's engaging in that sort of conduct, other competitors feel compelled to also have similar terms that are helpful for those customers, which they might not want to have. So you have to see how the industry dynamics really play out, and why are they doing things that they're doing? Is it because of a demand from customers? Is it because it's an industry norm or not? So that would help clarify a lot of this information asymmetry problem that we see often in regulatory decisions. The second thing that I think they really must do, which will save them a lot of time as well and make the investigations faster, is that they must encourage, communication with the opposite party in question. So you're already investigating somebody, and you can send them questionnaires and you can go on and on in that saga, but genuinely having a more open conversation in a way, or engagement in a way with them, or giving them the opportunity to present evidence upfront, even sometimes before coming to a prima facie view itself, will really help in saving judicial time and resources. You need not even launch an investigation in a lot of cases where, if you just invited them to start with, they would be able to come and give you a clearer picture and just dispel any issue upfront. And the CCI does do it, but it does it on a case-by-case basis. So even before launching an investigation, they may call you, to present arguments either in a written way or orally, but they may not call you either. So in a lot of cases where they don't call you, is the ball really being missed is the question, right? They could have just saved their time if they had given you that chance to engage. So engagement with that opposite party becomes very important, because it helps you overall to understand the company industry better, and it also helps you save your own time and resources where they really are required, right? I think apart from that, I think the investigation endeavors really need to be structured. So you have a number of diverse officers in the DG office, and the DG is their sort of investigative arm. So they have a number of diverse officers. Different officers get allotted different cases to investigate, and they quite have a free range, in terms of how they want to conduct that investigation. However, I think internal training and internally, I'm making DGs understand what the current law is, what the metric is, what are the right questions to ask or not ask depending on, a certain set of facts or circumstances, would really help streamline the investigation process significantly and lead to the correct sort of answers at least being solicited. As I told you, in a lot of cases, if you're asking the wrong question or you're asking it to the wrong party, then it's just volume. It's not really of any value. So to get that value out of this process, it's important that they know who to ask and what to ask. And for that, if they engage a little bit with the opposite party or with even a technical expert in that sector, they might be able to appreciate and understand what's relevant for that sector, which is missing right now in a lot of investigations. They're very, very shallow, and it's very easy to pinpoint holes in them. And it's unfortunate because the CCI otherwise is actually, one of the best regulators this country has. So if it could just strengthen that DG investigative arm through better internal training, or, have an appreciation for relevant evidence or relevant facts, on an industry by industry basis, even if not more narrow, then that I think would definitely lead to better outcomes. And I think in terms of timelines of investigation, having fixed timelines is something that they do try. Every prima facie order will give a DG about 60 days to give a report. But unfortunately, that's not something that realistically can happen, especially in a large case, especially in a case which involves, an industry with multiple players. So it's not really a practical thing that they really can do in a way. But, you know, um, you do want DGs to have flexibility while not being dragged into investigations for years and years on end. So, as I said, if there's a way to streamline the process a little bit internally, if they understand what the priorities are, what they need to focus on, that might automatically lead to quicker investigations. Having a strict timeline is not always helpful. We've seen it in some cases where the DG would just give us 2 days or 5 days or 7 days to collate thousands and thousands of data sets. And eventually that would result in not only human inaccuracy in collection, but then also disregarding of that data set, which is otherwise crucial pieces of evidence to be able to disprove any allegation against you. So you don't want that sort of inflexibility with the DG as well. You want them to have that time to be able to allow the opposite party to at least get the right data and give it to them. At the same point of time, as I said, if they focus their resources on just asking the right question, reaching out to the right party, that itself will save them a lot of time as well. So I think in that way, if they get those experts, they do internal training, and they appreciate the industry that they're looking into, we might see much better, quicker, effective outcomes through this regulatory process.
Right. So we have one last question for you, ma'am. This is regarding the ex-ante framework. So the ex-ante framework under the EU's Digital Markets Act and India's Digital Competition Bill, which has now been withdrawn, they mark a stark departure from the effects-based approach. So in your opinion, is that the right direction, or do we need to move beyond the effects-based analysis in cases of gatekeepers?
Yeah. So I think that's something that we we as a nation as well wanted to look at, which is ex ante regulation. And from news reports, I understand that they might want to withdraw the, draft digital competition bill in its current form. Um, Ex ante regulation sounds good on paper, but it is not without its challenges. We've seen implementation in other jurisdictions, and we've seen the challenges and issues that it's facing. So even where big tech companies or companies which are designated as these gatekeepers are sort of coming up, and they're offering these commitments to ensure that they are on the right side of the law, there are always disgruntled parties, and that engagement and that sort of process of bringing them to where they need to be is going to be very time consuming, and it's going to take forever. One thing that we must appreciate is that a lot of these companies are actually, companies with worldwide operations, and some of them may have certain units in certain areas and other units in other areas. So without understanding and appreciating how their internal dynamics, servers, interconnections work, it's unfair to give them very broad based parameters and say, oh, you must comply with this and you must do it in 60 days for our country, without seeing whether it would really impact their global systems or their global, mechanisms. And if there is a law which is effective in being able to tackle such conduct, through an ex post regulatory mechanism, like the effects analysis, for example, then that ex ante regulation may in certain cases end up, being futile as well. So if it has to be introduced, it should be introduced with enough clarity and safeguards, with a mechanism where the company has the ability to approach the regulator and approach them and say, you know what, you think I am a gatekeeper, but if you look at the facts, I'm really not. Or I was a gatekeeper a year ago, but now look, the market has changed. Digital markets are dynamic. Today I'm not. Or you had a problem with this conduct. Let me explain why that is not true, or I don't do it, and I should have the power. You should have the power to revoke the designation yourself. Or even if it is true, and I'm able to show you that I've made some changes or that there is enough, dynamism in the market, then you have to be able to give me that window of appreciation. Without all of that, which is what the draft in its current form was, uh, that sort of broad-based overregulation is what would end up penalizing, companies for innovation. And in fact, the opening paragraph of Schott Glass warns against that approach. It actually says that you shouldn't be penalizing companies just because they're big and they're innovating, because everyone understands that innovation is the cornerstone for any country sort of development. And at the end of the day, you don't want to penalize companies just because they had a first mover advantage or on paper they have a higher market share, especially when you look at digital industries, where you can see players like TikTok, for example, just blowing up in a short frame of time, and there will be somebody else right after and somebody else right after. It's just a question of having that product which grabs attention in a way versus another one. So I don't think it's something that is a sure shot success to have ex ante regulation or a sure shot requirement. I think it's something that any legislature should think about very deeply, and while thinking about it, have enough safeguards or have enough fallback provisions for the gatekeeper to be able to come and contest that analysis as well, or to be able to have the flexibility for the regulator to withdraw the designation and the company to be able to come and have flexibility to argue against that designation. Otherwise it would just lead to chaos and no other better outcome. So you must see it in light of the context of what the law, especially competition law in any jurisdiction, intends to do. And ours intends to promote competition and also help consumers. So if that's being achieved through the current mechanism in an evolving way, then we need to really assess for ourselves whether we need any more regulation or not.
All right. With that, we come to the end of this podcast. Thank you so much, ma'am, for taking out time from your busy schedule to talk to us. It was a very enlightening conversation.
Thank you guys. Thank you for doing this on a Sunday. And I'm again sorry for how long it's taken us to record this. So thank you so much and good luck to all of you. And yeah, let me know when this airs or is edited or whatever. I'll be happy to reshare it as well.
Thank you so much, ma'am.
Thank you, ma'am.